Welcome to the Supreme Court of the United Kingdom, where we are today hearing the second day of the appeal in the case of FS Cairo, Nile Plaza, and Brownlie. The issue in the appeal, in a nutshell, is whether Lady Brownlie can bring an action of damages relating to the consequences of a serious road accident which took place in Egypt, whether she can bring her action in this country. The court is at present hearing submissions on her behalf presented by Ms. Craza, Queen's Counsel, and so I turn now to Ms. Craza.
Thank you very much, my lord. Yesterday at the close, I was about to turn to the topic of the presumption of evidence and our submissions on that, if I may. To summarise the defendant's case on this issue. Oh, I'm sorry, Lord Legate.
Just before you do move on, I just have a question arising out of your submissions yesterday.
Yes, please.
You submitted that although there's no evidence to support the existence of a claim in contract under Egyptian law, we can safely infer that there is such a basis. I would find that submission easier to accept, but for the fact that you've served two quite detailed expert reports from Mr. Edge, who's clearly aware that there's a pleaded claim in contract, but has evidently elected not to address that subject. And I just wonder whether you can shed any light on why that is.
My lord, our submission is that Mr. Edge does address the contract issue. It's true to say that his second report takes a slightly different turn because he's invited to focus on specific issues which are away from the contract. But both experts proceed effectively on the assumption that there's a contract, because the debate between them was really about how that contract would be characterized as a matter of Egyptian law. So Mr. Ezo, the expert for the defendant, was saying that it only arose under the commercial code and would be characterized as a contract of transport. And that came with it special rules on limitation and also strict liability. And Mr. Edge's report was effectively saying, no, that wasn't so. It wasn't to be so characterized. The complaint, as we understand it, which is being made by the defendant, is not so much that there was no evidence of a contract. Indeed, it's conceded that there was, in fact, a contract. The issue was whether in that contract there was implied a term of reasonable skill and care. And so it's actually much narrower a gap that Mr. Justice Nichol was being asked to fill. And that's why I made the submission I did yesterday.
I misspoke perhaps, but what Mr. Edge doesn't address is any basis for asserting a liability in contract law.
That's right. I mean, I don't shy away from the fact that this expert evidence is not in the final form that you would want to present in order to present the case at trial. There is clearly more that can be said about the nature of the contract and the contract term. Our case is that that's almost passed by assumption by both experts. And we do rely on the fact that that may have come about in part because the defendant's instruction to its expert not to address the question. So I'm not sure I can. I'm not sure I can take it any much further than that. But we would not agree with the analysis that there's no evidence of a contract. And in looking at things in the round, there clearly is.
No, I'm sorry, I didn't mean to say there's no contract. There obviously is a contract, but there's no evidence that I could find to support your case that there's a liability under Egyptian contract law.
There is a gap insofar as we have pleaded that it is an implied term of the contract that the organizer would exercise reasonable skill and care when organising an excursion on behalf of his customer. That, we say, is the extent of the gap.
Okay.
Sorry, Lord Burrows.
Forgive me if I've misunderstood here, but I thought that there was no dispute that the contract gateway has already been held to be satisfied. I thought at first instance, you in a sense were already through the contract gateway. Is that wrong?
It's partly right. So obviously there's three parts to the gateway. We've got to show that we passed through one of the gateways, and so it's common ground that we passed through the contract gateway, and then we need to show that there's a serious issue to be tried, and then obviously it has to be held to be forum convenience. So forum convenience has been found in Lady Brownlie's favour. The only issue that's left on contract gateway is whether there's a serious issue to be tried.
Yes, thank you.
My Lord Legate, did I interrupt you asking a follow-up question?
No, thank you. You've answered my question.
Thank you. So in terms of the defendant's position on the presumption, as we see it, the primary case is what we would describe as a full frontal attack to the rule itself, because they say if you rely on a foreign law in your case, then the presumption can't apply. And when they use the word rely on, that in our submission seems to equate to where there is a choice of law rule that points to a law other than English law. And the reason they say that is they say that the choice of law rules themselves would be subverted, or another way of putting the same point perhaps is to say, well, the effect of the presumption is substantive, and there it should be treated as a substantive choice of law rule rather than a procedural one. And then they say if that's not accepted, then they have a narrower case which relates to the Fatal Accidents Act, and that's when we need to look at the cases of Cox and Shaker to see whether there's some kind of exception or difficulty with applying it to the Fatal Accidents Act. And then they say that there is a special rule that applies at the jurisdiction stage of assessment, and that somehow the presumption has a different use at the jurisdiction stage. And then I think finally, for good measure, they say, well, there's a line of cases which are an exception to the presumption, and this falls within them. So I'm hoping in the course of these submissions to tackle those points, starting, if I may, really with what we say about what the main rule is. We do say that the defendant's primary case on this is quite a startling proposition. It would be a very significant change in the law if it were held that the effect of the Rome Convention, which has been English law since 1990, and the 1995 Act and subsequently Rome I and Rome II are inconsistent with the presumption existing. And it would have very wide-ranging effects on cases in practice, because if you abolish the presumption, then what you have to do in every case in which a foreign law applies, you would need to plead and prove out and evidence every single aspect of that case prior to service out. So you're effectively front-loading the foreign law issues and making them all part of kind of mini trial on jurisdiction at the beginning. Yes, my Lord, Lord Legate.
I'm not sure I accept that premise of the argument, Ms. Crowther. Why isn't it perfectly acceptable to service out? To show, for example, that it's reasonable to assume, unless shown otherwise, that Egyptian law will have a law which makes somebody who negligently injures another liable. And it's only if that proposition is going to be in dispute that one may need to have evidence about it later. You don't need any legal presumption for that. It's just a reasonable inference to draw.
Well,
which you drew yesterday, indeed. And
well, my Lord, yes, I mean, that is my case, as you rightly pointed out. But the way I understand what my learned friend is arguing, and obviously she'll correct me if I'm wrong about this, but is that she says that because we have a substantive choice of law, then and in a case where, as this one, Egyptian law applies, then it's incumbent on a claimant to set out the detail of Egyptian law in every extent. So in practice, because you've got to do this before you know what the defendant is going to say, before you've issued and served your claim, before they've responded, in practice, it's going to make it incumbent on claimants to do all of that work and obtain all of that evidence, which is sometimes, one can speak from personal experience, extremely difficult to obtain. And to do all of that before they've actually even issued and served their proceedings, which may in fact be a complete waste of time for the point that my Lord Legate makes, which is, in the end, there might never be a point taken on it.
Well, I don't see why the presumption leads to that consequence. One can reject that consequence for perfectly simple reasons that you gave yesterday.
No,
it doesn't mean that we have to uphold a presumption, which seems to me at the moment to be very difficult to justify on any theoretical ground, which English law is applicable, unless Egyptian law is shown to be different.
Well, my Lord, I may be misunderstanding again, but it's not the presumption that has this consequence, it's the abolition of the presumption. What I'm saying is that this is the consequence of the defendant's case. And if you have the presumption, then we have the position that currently prevails, which is it's only, as my Lord points out, the extent to which either party asserts that the chosen law is materially different to English law that one needs to get into questions of pleading and proving it. And apart from that, it really isn't a material issue in a case. It's of no interest to the parties whatsoever if everything's the same, or if they're content to behave as if it were the same. So we say that it's the presumption is a sensible and pragmatic rule that reduces costs. Maybe I am misunderstanding the point, my Lord, but we say...
Well, I don't want to take it any further, but my point was simply that you don't need any that starts from the proposition that foreign law must be the same as English law. It seems to me a very parochial approach in order to reach a perfectly sensible result in inferring what Egyptian law is likely to be in this sort of situation.
Well, I mean, I hope it's not just a question of semantics, whether we call it a presumption or a rule of evidence or something else, but we do maintain that it's important, and it's very long-standing principle of the way that proceedings are conducted in England and Wales, that there is a large degree of party autonomy about the way in which disputes are brought before the court. And if the parties don't raise any issue of material difference in a foreign law, then that shouldn't matter. The court can proceed to, I mean, the court has to decide the case. They have to do it somehow. And therefore, it's a pragmatic and sensible approach, particularly if in practice, the parties are content to proceed on that basis. I mean, perhaps, my Lord, I could take you to what Lord Justice Mustill had to say on this topic in the Modaroglu case, which I submit sets out why it's a matter of practical and commercial convenience. It's at EF 4462, which... And the passage is at just above letter C. Lord Justice Mustill says, secondly, so far as my own experience has shown, most of these cases are decided solely in accordance with English law. Not so much because the court has applied the presumption that foreign law is the same as English law, but because in so many practical respects there is insufficient difference between the commercial laws of one trading nation and another to make it worthwhile asserting and proving a difference. And one can also see academic support for the rule in what...
Just before we leave that, can I just say from the rule is, or presumption, or whatever you want to call it, it isn't unique to English law. It also exists in Scots law and it's absolutely vital to the operation of the commercial court in Scotland, because so many of the contracts are governed by English law. But nobody takes the point unless there is a material difference which somebody wants to rely on between the relevant Scots and English law. But if we were to insist on people pleading, and it would be highly inconvenient, I think. Whereas as it is, you simply proceed on everybody just proceeds on the assumption that they're content to treat the contract as being governed by Scots law.
My Lord, yes, absolutely, and we would endorse that, and if I may be permitted to say so, that reflects my personal experience of practicing in this area, that's the way in practice that these things have to be done. Otherwise, proportionality goes straight out of the window. You can also see in the case of Marconi against PT Pan the importance to the English commercial court, and the reference is 2385, if I may, please.
I mean, that said, it rather sounds as though what Lord Leggett is contemplating isn't a very demanding level of pleading of the foreign law.
No, no, but in some respects, and without any disrespect to the case, which is obviously very important to all concerned, I mean, at heart, this is a running down action. I mean, there's a degree to which pleadings are to set out the material facts so that everybody knows the dispute. If we could go to 2385, please, which is the PT Pan decision. Sorry, I've got my wrong bundle out. One thing I've learned from this experience is that I will definitely be using the electronic authorities bundle next time, because this is much slower, so apologies. I'm looking at paragraph 70 of Lord Justice Potter's judgment, where he talks about the contract made within the jurisdiction. And he says, in deciding issues raised before the court which were asserted to be governed by foreign law, the court proceeds upon the basis that such law is to the same effect as English law, unless material is provided which demonstrates the contrary. Mere assertion is insufficient unless it is supported by credible evidence as to the foreign law. This is a necessary rule if proceedings are not to be stultified or unduly delayed, particularly in the interlocutory stages. And we do rely on those words because at points yesterday and in her written case, my learned friend was suggesting that somehow there ought to be a higher standard applied at the jurisdictional stage rather than a lower one. In any case, where the answer to a claim with a foreign element is clear so far as English law is concerned, it will often be the case that the material provided as to foreign law will be of an incomplete or provisional nature, unsupported, I apologise, by detailed authority, or by materials of the weight or complexity suitable to a final disposal, but nonetheless sufficient to satisfy the court that an arguable defence or other relevant issue has been established for the purposes of a decision at that stage of the proceedings. Obviously, at that point, the Justice Potter had in mind the authorities to which I took your lordships yesterday about the relevant standard at the merits test stage of jurisdiction. Nonetheless, the party who asserts the application of foreign law would provide a different result bears the burden of satisfying the court that it is so. We say that this raises an important point which is notably absent from the defendant's submissions. The key question in our submission here is the material difference. It's not enough simply to say that a choice of law rule points to the law of another country. What one has to do is look at whether either of the parties raises the fact that that law makes a material difference in the dispute that they wish to bring before the court. And then he continues, if the evidence is proffered is such incomplete, inconsistent or unconvincing character that it's insufficient for its purpose, it's not necessary for the opposing party to adduce his own contradictory evidence from an expert in the relevant foreign law. So again, my lords, we say that this is a commercially practical rule of long standing, and it would be a very significant change for it to be said to be abolished. There's also a history of the rule in the Glasgow case, to which you were taken briefly yesterday, and I don't think we need to turn it up again. But for your lordship's notes, I would invite you to read the full history that's set out by Mr. Justice Popplewell, which is between pages 2673 and 2677, which we submit is an accurate summary of the older cases and demonstrates the long standing of this rule. My learned friend in her submissions yesterday suggested that the Glasgow case was somehow to have less weight attached to it because it arose in the context of double actionability as the defamation field. But our submission is that we struggle to see how, in this respect, double actionability makes any particular difference, because the pleading and evidence issues are effectively the same, whether the incidence of foreign law arises as a result of a choice of law rule, or whether it arises as a result of a need to satisfy the double actionability conditions. In the end, the practical output is that you need to plead and prove any material difference in the foreign law, which would be relevant to the double actionability standard, or which would arise under the chosen foreign law. So we don't see that that is really a reason for those cases to be discounted. So looking, if I may, also at what the choice of law statutes actually have to say about this, we submit that it is a rule of evidence or procedure and is not substantive in nature, and therefore when one looks at the scheme of Rome 1 and Rome 2, or even the 1995 Act, if one goes back that far, it's difficult to see how those provisions could be said to have abrogated the previous position on the evidence rule. And that's in our written case at a paragraph 104, electronic reference 148. And this is the argument which we made to Lord Justice Underhill in the Court of Appeal, and he agreed at paragraphs 171 and 172 of his judgment, which is electronic reference 208 to 209. There are a couple of other references for your lordship's note. The 1995 Act, which obviously was the domestic provision for choice of law in tort until Rome 2 came in, had a specific reservation for evidence and procedure at section 14(3) little b, and you find that at 5278. And Rome 1 and Rome 2 have similar reservations, and that's in our written case at 106, which is 149. I would, however, like to turn up the Giuliano-Lagarde report, which was the precursor to the choice of law regimes in Europe. And if we could please look at page 3334, we can see in my submission that the Giuliano-Lagarde committee obviously considered the question of proof of foreign law and took the decision to keep it as a question of procedure and evidence, and therefore for national law. It's at tab 56. And the particular passage happens to start right at the bottom of the right-hand corner of 3334 under the heading Article 14, headed Burden of Proof. Article 14 deals with the law to be applied to certain questions of evidence. There is no rule of principle dealing with evidence in general, so they decided to leave that out. In the legal systems of the contracting states, except as regards burden of proof, questions of evidence, both as regards facts and acts intended to have legal effect, and as regards foreign law, are in principle subject to the law of the forum. They then go on to talk about other rules of evidence. So in our submission, the intention of the draftsman for Rome 1 and Rome 2 clearly had in mind foreign law as an element of evidence and procedure, which was to be reserved for the national law of the forum. It would be a surprising conclusion in that event if the effect of the substantive choice of law rules was to impliedly reverse a rule of evidence and procedure about proof of foreign law, because that would, it seems to us, fly in the face of what the authors had intended. Moving on, if I may, to how this question has been treated in the courts in England and Wales in other decisions. You were taken yesterday to the judgment of Lady Justice Arden in OPO against MLA, which is at 2323. We deal with this in our written case at paragraphs 103 to 105. I don't think we need to turn that passage up again because you looked at it in detail yesterday, but we do rely on it, and we say that that is an accurate consideration of the position as to how the Rome regulations interact with this rule of evidence. And also in Brownlie number 1, Lady Justice Arden expanded on her reasoning, and again you were taken to that, that's paragraphs 88 and 89 of her judgment, which is at 1822 and 1823. Now, my learned friend's submission on these cases was boldly that they're wrongly decided, and the way she puts it is she says that the choice of law rule is a matter of substance and not procedure. But we say that that submission is unsupported by any authority. One can't derive it from the statutes themselves, and there aren't any cases that support that. It is the essence of the point. I'm sorry, my Lord Briggs.
It is a possible reconciliation of this, that the choice of law is a matter of substance, but the means whereby you establish what chosen law is a matter of evidence and procedure.
I'm really sorry, my Lord, but you broke up at a key moment in the middle of that question, and I'm going to have to ask you to repeat it.
Let me try again. Is a possible reconciliation of this, that the choice of law is a matter of substance, i.e. the question which system of law applies, but that the identification of the provisions of the chosen law is a matter of evidence and procedure?
My Lord, yes, we say that's effectively the schema that is intended, and you see that from the Giuliano Lagarde report.
Yeah.
My learned friend's submission is the essence of Mr. Fentiman's point in his 1998 book. I mean, his central thesis is that because those statutes use the word shall, so Egyptian law shall apply, etc., that they've got some kind of mandatory status, and that therefore there is an onus on the court to achieve the outcome of applying that law. That's kind of the way that the argument works. Having said that, and I know you've got various extracts from the book in the bundle. I mean, the whole book is over 300 pages long, and it's a very impressive work, but it is rather discursive, and there's an element of blue sky thinking in it as well. But fundamentally, Mr. Fentiman does accept in his work that Glasgow and the Economist represents what the law is at the time of writing, because it was decided a year before. So it is all posited on the basis of a kind of lament, really, that Mr. Fentiman thinks that the law shouldn't be that. But we submit that he's wrong to have that lament. And in response, if it is going to be a war of academics, which I hope it won't be, We do rely on what Professor Briggs has to say, which is in the bundle at 3351. I'm not going to read all of this out. It's not actually a very long section. It's pages 7 to 11 from Professor Briggs's recent textbook on conflicts of law. I commend it to your lordships. It's written in Professor Briggs's, I hope you won't mind me saying this, pugnacious style. But he sets out at page 7 of the work at 3350. An English judge may not apply a rule of foreign law to an issue unless 3 conditions are satisfied. First, the conflict of laws rules which make up private international law must confirm that a foreign law is in principle applicable to the issue in question. Second, the party who relies on foreign law and wishes the judge to apply it, and we rely heavily obviously on those words as being the key factor, it must plead it. Third, the party relying on foreign law must adduce evidence which proves its content to the satisfaction of the court. Meeting these 3 conditions means that the judge will be enabled and obliged to apply a rule of foreign law unless a supervening rule of English law tells him not to. We submit that that is a pithy summary of where the law is, as long as one bears in mind that when Professor Briggs uses the word relies on, he's not doing it in the same way that the defendant's doing it in this case. He's saying that there's a material difference and that there's a point that somebody wants to prove. And he does say this over the page at 3351. Unfortunately, the paragraph's rather long. It's about halfway down the top long paragraph. He says, according to the English way of thinking, this is so even when an international convention or European regulation stipulates that an issue shall be governed by a particular law. It's sometimes wondered if the relaxed-looking approach taken by the common law is consistent with a legislative instruction, say from the European Union, that the law arrived at by applying a statutory conflicts rule shall be applied. Not everyone will consider it correct to understand this, so it actually said shall not be applied unless one of the parties chooses to plead and succeeds in proving it. Yet the point has not really been taken. And we do rely on that. I mean, the Rome Convention is a reasonably long-standing. I mean, it's a fairly modern suggestion that it has made this change. Presumably a substantial number of cases with foreign elements, because it would have a dramatic effect on the way the English courts, which try a substantial number of cases with foreign elements, adjudicate. If a change in practice is to take place, it will require a clear and precise direction from a legislator, to say nothing of an impact assessment, to say how it is justified. So far, neither such thing has happened. And while we're here, there isn't a passage which might be of relevance later, so we can look at it now. I hope you don't mind me taking it slightly out of turn, but on page 9, he talks about cases which involve status or proprietary rights in rem, and the extent to which party autonomy to choose whether to apply the choice of law can really extend to those. The sentence starts here, but in cases where the court is called on to decide an issue which may have an effect in rem, such as whether B obtained good title to a car from S, or whether H and W were lawfully married. I think the Lacon case found its way into your lordship's bundles. This relaxed approach to foreign law is less compelling, for a ruling on status may well have an impact on non-parties, such as a subsequent purchaser or an intending spouse. I mean, obviously that's not this case, but we do say that some of the cases where the courts have been reluctant to allow the parties to proceed on the basis of English law, where a foreign law would normally apply, can be explained on the basis that they have impacts on third parties wider than the parties to the dispute. So we say that in terms of what the law actually is, the most useful statement of it is that of Mr. Justice Andrew Baker in the Iranian Engineering and Dean decision, and we find that at 2120. and the relevant passage starts at paragraph 13. At 14, he picks up the global multimedia case to which your lordships were taken by my learned friend yesterday, and makes the observation, which we respectfully adopt. With respect, the quoted passage begs the issue whether relevant principles of foreign law were material facts required to be alleged. And to my mind, there is a confusion throughout between A, the need to plead and prove propositions of foreign law if relied on, and B, whether there is a need to rely on and therefore plead and prove foreign law. He then makes the same observation about the decision in Belhaj, before pointing out at paragraph 16 that Belhaj was a striking and very unusual case. Mr. Belhaj and his wife asserted causes of action against a former foreign secretary and other ministers, officials, departments and agencies of Her Majesty's government in respect of the defendant's participation, as the claimants alleged, in what they said had been their unlawful rendition from China to Libya via Malaysia and Thailand. So what was being said was that the rendition was unlawful and that the breaches of duty would necessarily have depended on provisions of all the laws of those countries as to whether it was permissible for the acts to have taken place. Two preliminary issues were ordered. Firstly, whether the claims were non-justiciable because of state immunity, and secondly, what was the governing law. And then what developed was a kind of standoff as to who needed to plead and prove first as to what that governing. So it was kind of common ground that in the end somebody would have to do it and that it was going to be different. But what was happening was a kind of tactical standoff as to who was going to go first, as to set out what their case was on what everybody agreed in the end were going to be those material considerations. And one can pick up throughout the judgments a sense of some exasperation with the claimants in that case, that on the one hand, they were saying, well, we will produce all of this by trial and inevitably it's going to be an issue and it's all going to be difficult, but you can let us through. You can let us through now. So he sets out at paragraph 17, which I won't read in full, all the ways in which Belhaj was unusual, but I do commend it to your lordships. But at paragraph 18, we say that Mr. Justice Andrew Baker gets it right. Basically, it was a case management decision in the specific circumstances of Belhaj, and it was basically claimants go first. But what he says at paragraph 20 is that I do not read that paragraph from Belhaj as laying down a rule of general application that where a claim is governed by foreign law, the claimant must plead a case as to the content of that foreign law. If I'm wrong in that, and the Court of Appeal did intend to state such a general rule, then it was not necessary to the decision in Belhaj, and it is consistent with what Lady Justice Arden had to say in OPO and Brownlie number 1, which I've said I find compelling, and I would decline to follow it. He notes that OPO was not cited or referred to by the Court of Appeal, and we've already heard that the two cases crossed over a bit, so they weren't cited to each other. And then at paragraph 21, he picks up the point which I've already made to your lordships this morning. I regard as unnecessary the decision in that case and inconsistent with Lady Justice Arden's more telling analysis, and will not follow the statement that we do not accept that section 14(3)(b) of the 95 Act, which provides a saving for evidence pleading or practice, affects the position. The issue of applicable law is one of substantive law, not procedure. If that is to say, the statement were intended as some of the general rule rather than an observation applicable in the particular circumstances of Belhaj and Straw. Application of Rule 25(2), that's the dicey classification, a matter of procedural law in English courts, and its impact on questions of who must plead what, does not touch the substantive question of applicable law, but it does affect the relevance of that substantive question to the determination of the private law claims brought in ordinary civil litigation. In our adversarial system, it's primarily for the parties through their pleadings to decide for themselves and define for the court and each other what is or is not to be relevant to the resolution of the dispute. My analysis recognises and allows the possibility of the court of its own motion, insisting that an issue is not raised by the parties considered. And then I would also invite your lordships to look at paragraph 11 of the judgment, which is set out by Lord Justice Underhill, in his decision in the Court of Appeal, and the reference to the Brownlie Court of Appeal judgment is EF 197. Lord Justice Underhill sets that out in full and says that he agrees with what is said at paragraph 11 as an accurate statement of the law. I'm not proposing to read that out, but I am wondering whether to pause briefly to allow everybody to read it in case any questions arise from it.
Yes, please, that'd be helpful.
Yes, my Lord Legate.
I'd just be interested to hear what you say the boundary, if any, of the rule is, because I have no problem with the general assumption in an ordinary sort of commercial personal injury case, but a general rule that a defendant could be hauled over here to defend a case on the starting basis that some idiosyncratic provision of English law must govern his claim unless he proves otherwise when it's known to be based on foreign law, seems to me a difficult one to defend in the general scheme of things.
Well, my Lord, put that broadly, we'd be very much inclined to agree with you. We will readily acknowledge that there are exceptions to this general rule, one of which is where the rule in question is sufficiently idiosyncratic that it would be artificial to make that assumption. And I will come on, if I may, to look at some of the authorities which address the question that what the court has to satisfy itself of is that the nature of the rule which is being deployed, and also we would submit relatedly the purpose for which it's being deployed, are such that the court can be comfortable and confident that its assumption of similarity is not unrealistic. And perhaps it might be a sensible point, therefore, to have a look at the Shaker decision, because in my submission, that case, which was looked at briefly yesterday, is deserving of a little more consideration, because I think if one looks at it in full, you can see that that is what was being grappled with there. The reference is 2541, my Lord. Oh, I'm navigated away from Bell Hurge before anybody else had a chance to ask any questions. Shall we come back to it, or maybe we will? Let's go to 2541 first. So, starting at paragraph 60 of the decision, right at the end of paragraph 60, the letter D, the issue is defined here as whether it was a breach of duty by Mr. Badrawi to abstract the funds to A&A Inc. Whether it was appropriate for the court to apply English law, as there was no other evidence of Pennsylvanian law, being the law which would otherwise apply to the question of whether the director of a company had acted in breach of its duty to the company. So my first observation is that it was a standard of care issue that was being looked at here. They were saying that basically the content of the duty is by reference to English law, even though we're looking at Pennsylvania. At paragraph 61, the court sets out the legislative history of the specific provision of the Companies Act, observing that it was passed for the purposes of implementing the UK's obligations to the European Union under the second EC directive on company law, which was a harmonisation measure, but also which changed the previous law in quite a specific way. What in fact that law did was required audited accounts to have a certain form. And it was only if there were audited accounts in a certain form, in accordance with the prescription in the law, that a distribution from dividends could be made. And you can see at the end of paragraph 62, the Court of Appeal picks up this point. It's a harsh consequence and a matter on which different legal systems might take a different view. So they're observing there that this is the kind of situation where you've got a specific rule of local standards as to what is appropriate accounting, where it's very likely that there will be differences based on local conditions. Previously, under English law, it had not been necessary to have relevant, that's the meaning from the legislation, or any accounts. And you were taken, I think, to 63 and 64, or maybe not 64. I think we need to just have a look at letter B on internal pagination 372. So that's 2543 in the electronic numbering. They refer there to the case of the ship Mercury Bell and Amazon, which is a Canadian case, where the court recognised the undesirability of applying purely local legislation to disputes having no connection with the jurisdiction. It rejected any simple division between the common law and the statute law. And I do rely on that, because I submit that it doesn't make of itself any difference whether the law of English law is derived from a statute or the common law, and held that domestic statute law could be applied under the default rule where the statute had potentially some degree of universality, which is support for my proposition that what the court has to look at really is what is the nature of the rule that you're looking to apply, and also what purpose are you applying it for. And if there is sufficient degree of universality, then you can apply it. And it then goes on at 66 to pick out the details of what relevant accounts mean in the context of the law and the specific requirements. And my learned friend took you to 66 and said, well, what you're basically doing is you're adapting the statute. We would submit, actually, the analysis is slightly different than that. The point wasn't so much that the statute was being adapted. The point was that the statute applied to a different situation. The statute applied to an English registered public company, public listed company, and the facts of the case related to a private company in Pennsylvania. And so it wasn't a question of, are you adapting the statute? It was a question of, is it relevant at all? Now, I appreciate that what counsel then tried to do is massage the difference by saying, well, you can tweak it here and tweak it there. What they conclude at letter F is, we find it difficult to accept that if English law is to be applied as a lex causae, it can be applied in a form adapted to the degree necessary on Mr. Lyndon Stamford's argument. Either it applies to a Pennsylvanian company or it does not apply. Excuse me. So the relevant findings I would submit are, starting at 67, the starting point is that not every English statute is to be applied. And then particularly the last paragraph of 67 and 2544, if a rule of English statute law has to be adapted in the way explained before it can apply, then although it is not necessary to express a final view on this point on this appeal, It may well be that that fact alone is sufficient indication that the case falls within the class of case where English statute law creates some special institution and thus cannot be applied simply because a party has failed to prove the relevant foreign law. So it wasn't necessary for the decision, but that's an indication of what the Court of Appeal thought there. And at the end of paragraph 68, they observed there is no evidence to suggest that the provisions of Part 8 represent requirements of company law generally recognised outside the European community, and Mr. Lyndon Stamford did not seek to so to suggest. And at letter F, you can pick up the point that I've made, that the judge did not assume and could not assume that A&A was a public company. Should the court accept the second directive as sufficient to show that a principle of company law is generally applicable not just to public companies, but also to private companies? So you can see that the facts were different. But I do also rely on what the court then observed at paragraph 71 of its judgment, which is at 2545. In those circumstances, which refers to, sorry, I should start at paragraph 70. On the assumption at trial there is an issue as to legality of the distribution made by Mr. Badrawi, and if at trial Mr. Shaker fails to prove the applicable foreign law, the court is not satisfied that the requirement for relevant accounts is some special institution of England law so far as private companies are concerned, then the prudential principle will apply. In those circumstances, if Mr. Shaker fails to prove the foreign law and Part 8 is inapplicable, the court will still be able to apply the common law rule that a dividend must be paid out of profit. So it's not that they were striking out the case or saying that it didn't have merit. They're just saying you can't rely on the special statute. And so it doesn't follow from any observations about the FAA, whether they're right or not. And I'll come on to make submissions that say they're not right. But even if they are right, it doesn't follow that the answer is to strike out the case. That's not what the Court of Appeal was saying in Shaker. They were saying what you can't do is establish breach of duty by reference to a special provision of the Companies Act, which was made to implement EU law, which on any view can't be said to apply in Pennsylvania. So perhaps if we go to have a look at Cox and Ergo, which is the basis for my learned friend's submission that the FAA is somehow a special statute that you can't do this to, excuse me. And I think the reference, which I've now lost, apologies. Forgive me, I've missed a reference out. It's 1934, I'm sorry, my lords. Now, the first thing to observe about Cox is that the issues in Cox were very different from the issues that we're now looking at. It was a case about applicable law, and there was no dispute about jurisdiction. And what had happened was a trial of preliminary issues was directed on the question of what was the applicable law. And at that trial, evidence of German law had been received and findings made on the basis of pleadings of German law and evidence of German law about what German law was. So by the time it reached the Supreme Court, it already had findings of that it was common ground that German law applied in principle under Article 4.1. It was common ground that what the German law was, because that had been found and not appealed. And we knew that in many significant respects, it was different from what the Fatal Accidents Act would have provided. For example, in German law, there is no equivalent of Section 3, subsection 3, which is about the prospects of a widow remarrying. And there is no equivalent of Section 4, which is the disallowance of benefits arising from the death. and there is a principle of mitigation, so that a dependent has an obligation to act reasonably to mitigate his loss, which also is not a feature of damages under the Fatal Accidents Act. Now, we don't need to get into all of that, but I paint that background simply so that your lordships understand that what was being suggested by the claimant in Cox is, notwithstanding all of that and all the findings, was that she could nonetheless rely on Section 3.3 and Section 4 of the Fatal Accidents Act for the purpose of assessment of her dependency claim. And unsurprisingly, in my submission, the Supreme Court said that wasn't going to wash. Now, the primary basis on which it was put forward that the Fatal Accidents Act might nevertheless apply, notwithstanding all those features, was to argue that it was an overriding principle of English law that would override the choice of law, or that it was a matter of public policy, so that even though there was a substantive choice of law for German law, these rules of English law would apply nevertheless. Part of the argument was about the territoriality of the statute. So the first observation I would respectfully make is that when Lord Sumption is dealing with this question, he's dealing on it on the question of, and you can see this at, if we go to 1941, he sets out at paragraph 4 the extent to which the claimant's recoverable loss is limited under Section 844 of the BGB, and also sets out the findings of Sir Christopher Holland, who had made those findings, and at paragraph 6 what those findings actually are. And then there's discussion about whether the provisions of the FAA are substantive or procedural, and we see that at paragraphs 13 and 14. And Lord Sumption rejected the contention that sections 3, 3 and 4 were procedural and therefore applied notwithstanding the German applicable law. And then at paragraph 24, we can see where he concludes, and 24 to 26, we can see that he concludes there was no overriding effect of English law. It's in that context of having made those findings that he then comes on to consider extraterritorial application. And what he says at 27 is that it depends on, extraterritoriality depends on its construction. And he refers to Clark and Oceanic, which is the long-standing authority on territoriality of statutes. But then he says at 28, it's important to understand what we mean when we talk about extraterritorial application. There are two distinct questions, not always distinguished in the case law. The first is the proper law of the relevant liability, and the answer will usually depend on the extent of any connection between the facts that give rise to liability in England or English law. If the proper law of the liability is English law, no question of extraterritorial application arises. In principle, the exercise is no different from that the court performs when it identifies the proper law of a non-statutory tort or by reference to the connection of fact and alternative systems of law. At 29, it's common ground that lex causa applied private international law is not English but German law. There's nothing in the language to support extension. It refers to the high seas cases, the SO Malaysia, and where English law was applied, and then goes through the maritime tort cases before at 34, which is 1952, makes the finding, now the terms of the purpose of the Act depend for their effect on having extraterritorial effect. But then he says at the bottom of paragraph 34, referring to section 14.3 of the 95 Act, some foreign laws governing the availability of damages for Fatal Accidents Act may be no doubt so offensive to English legal policy that the effect would not be given to them in an English court. A rule of foreign law that women or ethnic minorities should have half the damages awardable to white males, similarly placed, is cited as an example. But the German rules with which this case is concerned are based on a perfectly orthodox principle, which is by no means unjust and accepted in English common law. He then goes on to say, I've missed the reference. That's the bit where he says, sorry, apologies, I missed a reference. It's a paragraph, if we go back to 1948, I do apologise. Why can't I find it? It's not in my note. Can you help me? With the bit where he says that the common version. Yeah. Sorry. Thank you. I do apologise. It's paragraph 21 that I'm looking for. So at paragraph 20, he agrees with the Court of Appeal that the Fatal Accidents Act can't be applied to a cause of action which is under 844 of the BGB. But then he says at 21, if the English court must apply its own rules of assessment, then what are the rules if they're not the rules of the Fatal Accidents Act? It's not necessary to resort to analogies because English law does provide a remedy that harmonises with the German law right, namely damages. The driver committed a tort under German law and therefore incurred a substantive liability to pay financial compensation. The principal head of loss was deprivation of the net financial benefit of her right to legal maintenance from him. This is entirely cognate with the corresponding remedy in English law. It's true, as the Court of Appeal pointed out, that because the cause of action in English law for a fatal accident is an action under section 1, there is no non-statutory measure of damages for fatal accidents, but it doesn't matter. If, as I consider, the particular rules of assessment do not apply as a matter of construction, then the answer must be sought in the rules of assessment which apply generally in English law in the absence of any statute displacing them. We say that is very similar to what the Court of Appeal was saying in Shaker. The relevant English principle is put Mrs. Cox back in the position she would have been, neither better nor worse, if her husband had not been fatally injured. So the answer wasn't that there's no claim. The answer was that even if you can't rely on the FAA in the teeth of the findings, the common law would apply, and it's the same remedy. Against that background, and in the context of this case, we would make the following submissions. First, oh, sorry, my Lord Legate, yes.
I probably missed something, Ms. Crowther, but I haven't understood why this case is relevant at all. Because
well, that's going to be my first point.
About what the interaction between procedural and substantive law, where English law is the procedural law and the foreign law governs substance, is not a case about the presumption of the court rule at all, I don't think.
No, well, that was going to be my first point, my Lord, but I wanted to make sure that your lordships had kind of appreciated what was actually going on in Cox, because it felt, well, now we've been through it, so I hope I haven't wasted all your time. But we do say it's not relevant for those reasons. We also observe that we're not relying on the presumption for the purpose of establishing a claim for wrongful death damages, because that is all evidenced, and we looked at that yesterday. The only relevance of this point about presumption is on the question of whether there's a duty of care in tort or implied term of contract for an organiser to his customer to exercise reasonable skill and care. And so my submission is we don't need to go anywhere near all these cases about the Fatal Accidents Act, because we're not relying on the presumption for that purpose. We've got evidence that Egyptian law has a remedy and that it covers these heads of loss. To the extent that it's relevant at all, it's purely to the pleading issue. But my Lord Legate has the point that the presumption wasn't an issue here, and Lord Sumption wasn't being asked to decide that. Which takes me finally to what Lord Sumption said about Cox at paragraph 18 in Brownlie number 1, to which were taken yesterday. We don't need to go back to it. And my submission on that is short, and he correctly summarised what the court had decided in Cox, but it doesn't take this discussion any further, because in Brownlie number 1 he wasn't looking at the presumption either, and it was a different set of pleadings. Now, my lords, I've probably got about 15 minutes more of material on this topic, if you're happy for me to continue for the time being.
Yes, certainly.
So I would like to move on to look at some of the other cases that the defence have referred to as suggestion that the presumption doesn't apply, particularly cases where there's a proprietary or in rem issue, or whether it affects status. And I've already taken you to what Professor Briggs says about that at 3352. The Mother Bertha case is in the bundle, and the head note at 2261 for your lordship's note. I don't think we need to open the case particularly. The short point that we make on the intellectual property and proprietary cases is that these schemes of rules are inevitably closely tied to local circumstances of commerce and industry, because what it amounts to in many cases in intellectual property is the operation of competition and markets, and the granting of monopolies in respect of certain operations and things like that. It would be wholly artificial in such cases for an English judge to assume that a rule of English intellectual property law is the same as law elsewhere in the world. And we submit that that line of authorities is adequately and properly explained as an exception for that reason. Another grouping of exception cases, one of which we've already looked at, which is Belhaj, is those cases where for case management reasons, the court has refused to allow a party to take advantage of the default rule, essentially because it would be inherently unfair and would not meet the overriding interests of justice. And primary among those examples is the Tamil Nadu case. If we could look, please, at 2661. Now, in fact, actually, we should start at 2650 at paragraph 50, because the first observation that one needs to have in mind when looking at Tamil Nadu is that the case was actually decided on the basis of English law, and you find the finding at paragraph 50. And then at paragraph 51, Mr. Justice Cook says, because matters of Indian law have been fully explored before me, I'll go on to determine them without need to explore every aspect of the Indian law evidence. So technically everything from paragraph 51 in this judgment is over to Mr. Justice Cook's reasons. But we can pick it up again at paragraph 97. And the context of this part of the judgment arises in a late application by TNEB, one of the parties, to amend their case. And as a case management decision, Mr. Justice Cook refused to allow them to do that. And what they sought to do, TNEB, having had a list of issues agreed in advance, which did not include the new issue that they wanted to raise, and both parties having instructed their experts for trial on the basis of the agreed list of issues. They then sought to raise new matters about interpretation, either under the Indian General Clauses Act 1897 or in the alternative to rely on section 17, subsection 2 of the English Interpretation Act 1978. And one can see that the judge was unimpressed by the way that the application was put, as it had a degree of arm twisting in it. And essentially it was said, give us permission to rely on this fresh Indian law evidence, or we'll rely on the presumption anyway. So you've not really got a choice, Judge. At 98, Mr. Justice Cook says, I can see no basis for allowing TNEB to rely on any presumption as the equivalence of Indian law with English law. The artificiality of such a presumption when the parties have been permitted to produce experts is obvious. To overcome this, they wanted to put in the General Clauses Act for a different purpose, to show that it was similar to the Interpretation Act on which it was said to be based. And at 99, it would not be right to allow this issue to be determined in the way. There was an agreed list of issues. The whole purpose of the issues and the order for expert evidence was for the parties to set out and prove their respective cases on Indian law for the defined issues. It would be wrong to subvert that by allowing reliance when, as a result of its actions or inactions, the Indian law evidence, in accordance with the case management order, did not cover the issue now to be raised. He refers to Fentiman. But then at letter D, he says the presumption is aimed at the situation where foreign law is neither pleaded nor proved and the parties in the court are taken as content to proceed on the basis of the presumption, since no one has sought to establish that there's any relevant difference. If the failure to prove foreign law by a party is a result of a tactical decision after seeking to rely on it, reliance by that party may amount to an abusive process depending on the circumstances. And then again at 101, he refers back to the list of issues in the case management. But importantly, at 102, having then looked at it, he then says, I consider in any event there's nothing in the point. The argument is that Section 8 of the Indian statute, or the equivalent section, means that the references of 48 Acts and other instruments to which TNEB refers have to be read as referring to the 2000 Act which repealed it. This is not correct, and he explains why. So in my submission, not only is it a case management decision, but he was clearly influenced by the fact that it would have been wholly pointless to look at that evidence anyway. My submission is it's very difficult to derive from that decision any broader principles about the extent of the rule, particularly of any application to what use is being made of it by the judge in this case. It's not an artificial application of the rule to say that in a situation where a hotel organises an excursion for a customer, that it is going to be under an obligation to exercise a reasonable skill and care in doing so. We would have thought that that would be more anomalous not to be included than it is. It's a clearly a general universal principle. We don't fall into any of the exceptions. There isn't any special test that applies on jurisdiction, and it seems to us that it's difficult to think of a more universal issue, as Parker and Toohey that you're taken to or referred to yesterday highlights, than whether a duty of care, reasonable skill is owed. And so for those reasons, in those circumstances, we invite you to uphold what Lord Justice Underhill and Lord Justice McComb in the Court of Appeal have said about that in relation to their assessment of Mr. Justice Nicol, and to find that there is a serious issue to be tried on the merits, and to the limited extent that it is necessary, Lady Brownlie can be permitted to rely on the presumption in order to achieve that test. That was everything that I wish to say on the presumption issue, my lords, unless there are any further questions.
Well, yes, Lord Burrows.
Just so I'm absolutely clear, as I understood it, and I think you set this out in detail at paragraph 74 of your written case, you're putting to one side the vicarious liability. You're putting to one side these issues about limitation and cumul in that context, because you say those issues have either been accepted by the other side or have already been decided and there's no appeal. So that we're purely dealing here, are we, with the direct tort claim and the contract claim against the hotel. And it's only in that narrow, one might say, against the whole context of this, relatively narrow range of issues that there's any disputes. Is that right?
My lord, we'd say it's even narrower than that, because we say it's about whether there exists a duty to exercise reasonable skill and care in both contexts.
Yeah. Okay. And then one might say, and it may be the same as your universal principle, that it would be very odd for any legal system to recognise vicarious liability, but not direct tort liability. And it would be very odd for a system, any system of contract law, not to impose, if there is a contract, a standard of reasonable care. You might say, oh, well, there's an issue about whether it's strict liability, but at least it would impose a reasonable standard of care. So is it not an argument that you're putting forward that you never even need to get to the presumption, because it's just so, in a sense, obvious that any legal system is, once one's narrowed this down, is going to accept as a matter of generality those aspects of law? Or am I missing something here?
My lord, no. I mean, it comes back to the point that I made at the very beginning of my submissions yesterday afternoon, that the task of the court on the jurisdiction test is to look at the case in the round and to step back and say, is there a serious issue to be tried? And we'd say there plainly is. The extent to which one needs to rely on the presumption or not in that context, we submit is, well, at best a sub-issue, and possibly not even that. My lord, we say it's obvious peradventure that not only is there a reasonable claim here, but a very strong one. I mean, particularly bearing in mind that the driver was convicted of negligent manslaughter and went to prison in Egypt.
Can I just clarify, Ms. Crowther, the vicarious liability is the vicarious liability of the hotel for the driver, right? Direct liability in this case is the direct liability of the hotel, isn't it?
That's right. So, without straying into yet more authorities, one might be familiar, wearing a different hat, of the case of Wilson and Best, which talks about tour operators, and what Manwi, which is a Privy Council decision on similar lines. But basically, as a matter of English law, the organiser of an excursion has a duty to, for example, ensure that there are competent providers and that it's not so obviously dangerous that no reasonable tour operator would offer it to his customers. I mean, it has to be said, it's not an especially onerous duty in English law, but it arises as a matter, it arises as the implied term of reasonable skill and care.
Well, there'll be nothing bizarre about a legal system imposing vicarious liability on the hotel for the negligence of the driver, if there's an appropriate relationship between them, without imposing a direct liability on the hotel on the basis that it was itself at fault. I mean, it might or it might not be.
Well, I'm not sure respectfully we would agree with that proposition, my lord. We say that it would be quite remarkable for a hotel to send its customers out into the tender mercies of the wide world without any regard whatsoever for what they were doing, that they could hook them up with the nearest cowboy, knowing full well that they weren't fit and competent.
Well, you're building a lot of assumptions into that. But for example, a bus company in this country isn't necessarily directly liable whenever a bus driver has an accident, but it will be vicariously liable for any fault on his part.
And that may end up being almost exactly the dispute at trial, because the reason that the bus company might not have any liability is because it might be said to be some kind of transport contract which is subject to a special regime.
Or is it to take unreasonable care in the selection of its drivers?
Well, absolutely. Well, proving breach of duty may be a different issue, but the question of law is there a duty in the first instance, which we say arises, beyond a discussion, really.
I see. Well, if you've completed that first topic, then this, I think, would be an appropriate moment for us to adjourn. We can resume in 5 minutes' time. Yes, Ms. Crowther.
Thank you, my lord. I'm going to deal with, if I may, now with the tort gateway point. I'm going to start by setting out in terms what our case is. We say, first of all, that gateway ground 9 is a general rule which applies whenever a claim can be said to be tortious in nature, and it is a flexible application given the wide range of potential circumstances which fall within its ambit. Secondly, we say any significant damage sustained inside England and Wales is sufficient to meet the threshold test, or pass through the gateway, depending on your preferred metaphor, and to pass to the forum convenience stage of the assessment. And thirdly, we submit that the question of damage in the context of personal injury is the harm to me, the injured person, wherever I am and for as long as I feel it. I'd like to start with a few references to the evidence so that your lordships have the relevant pages so you can see what is claimed in this case. You were taken to the particulars of claim, the amended particulars of claim, so we don't need to go particularly back there, but at 237, which is in the core volume, at paragraph 36 is the pleading of the general damages of Lady Brownlie: fractured clavicle with displacement, rib injuries, soft tissue injuries to her foot, concussion and a psychological injury. There was medical evidence from Mr. Davis, which is also in the bundle at 526, and particularly if one looks at 527 to 8, section 14, where he gives his prognosis and opinion at 530. There is a preliminary schedule of loss, which is in the bundle at 327 to 330. It claims the estate's losses, bereavement damages or moral damages for loss of a spouse, loss of financial dependency on the deceased or loss of a right to be financially maintained by him, and also Lady Brownlie's personal injury damages and expenses and losses arising out of those. In broad terms, we say that injury to a person is a very specific kind of interest. It affects more than the financial sphere, which is reflected in non-pecuniary damages or in property cases, and includes physical pain, suffering, injury to feelings, loss of companionship, family ties, loss of amenity, loss of love and affection. It is in no way the same as an economic interest. And in personal injury claims, we do compensate in money, but money is not being used to replace other money. It's being used as a substitute for things that are far more important than money, on the basis that money is the best that the court can do. And Lady Hale recognised this very well in Brownlie number 1, and the reference is 53 of her judgment, and that's at 1796. She said, "If I am seriously injured in a road accident, the pain, suffering and loss of amenity that I suffer are all part of the same injury, and in cases of permanent disability will be with me wherever I am." Similarly, Lord Justice McComb in the Court of Appeal in Brownlie 2 said that it's artificial and arbitrary to seek to divide injury to the person in the way that one might seek to delimit harm to an economic interest. He said, "To my mind, the distinction between direct and indirect is virtually meaningless in the present context when one is asking oneself the proper question whether a claimant has suffered significant damage in the jurisdiction. There's no need to import legalistic niceties inherent in the concepts of direct and indirect damage." And he says that at paragraph 53 of his judgment. at electronic reference 180. And in our submission, those statements are both from experienced personal injury specialists who would understand. Yes, my lord.
It's all very well to say that, but the distinction's drawn in deciding on the applicable law, isn't it? And it works adequately in that context.
It's a different question though, my lord, isn't it, applicable law, because there can only be
of course it's a different question, but the question is whether the distinction makes sense or not. And you're suggesting that it can't reasonably be drawn, or it's artificial. Well, I'm just putting to you that it can perfectly well be drawn, because it is, albeit for a different purpose.
But with respect, my lord, it is because the purpose is different that the distinction is different, because there can only be one applicable law. So the law has to have rules or a way to find what that one applicable law is. But
that doesn't make any difference, does it, to how you distinguish between direct and indirect injury? You may say that there may be good reason to have a different rule in jurisdiction. All I'm suggesting to you is that it's not a good reason to say that the distinction doesn't make sense.
My lord, what we're doing here is a process of statutory construction of the words of the statute, and we say that there is nothing that one gains from the applicable law exercise that helps you interpret the scheme in the jurisdiction context, and there is no good reason why they need to be concomitant for common law purposes.
I'm not repeating that. Perhaps you haven't understood the point.
I probably haven't.
I'll just try once more. I accept that it doesn't follow that because a distinction is applied in applicable law, it should be applied in jurisdiction. All I'm suggesting is that the distinction can be and is drawn in the context of applicable law, and that's a good indication to show that it's a perfectly tenable distinction. Whether it should be drawn in jurisdiction is a different point. But you were quoting Lord Justice McComb, suggesting that it's artificial and you can't work out which is indirect and which is direct, and therefore we shouldn't apply.
Well, my lord, we're at risk of going round in circles, but my submission would be that there's no inherent inconsistency between having the direct-indirect rule in the European scheme, which is the applicable law scheme, where you've got to have a single applicable law, and that is one way of doing it. There's nothing inherently inconsistent between that and looking at the common law rule against the background of what you're doing there, which is jurisdiction. And what Lord Justice McComb is doing is what we would submit is the right thing to do, which is to look at the words in the jurisdiction rule in the context and for the purpose that they're being used. So, like I say, we're probably at risk of going round in circles, but that we would say that there's no obvious inconsistency there, and there's no reason in principle why it can't be different.
I'll give up at this point.
I hope I'm not a source of frustration, no more than usual. Can I have a look at the natural and ordinary meaning of the words "the damage was sustained"? We depart almost immediately from the defendant's analysis in that we say that we do start with the words themselves, and it would be useful, I submit, to have a brief look at them in the context of their original version, and it's at 2918. So at 2916, we can see that this is the original version of the statutory instrument in 1983. And what was then ground F of Order 11 Rule 1 is halfway down, page 2918. And it says the claim is founded on a tort and the damage was sustained or resulted from an act committed within the jurisdiction. We do make some basic points that on the face of it, it's very difficult to deduce any limiting intention from the words themselves, and sustained is a broader word that could have been used, such as arises or occurred. And we do also make the point that if it had meant damage sufficient to the cause of action or completion of the cause of action, then words could have been used to the effect of achieving that objective. Or if it had meant direct or indirect, it could have said so. I know these are all basic and obvious points, but the words themselves do have a very natural and obvious meaning. It's difficult to see from the face of it why we need to read it any narrowly. I would like a little bit, if we may, to look at some of the background history as to how that rule came about. And one case which Lord Sumption refers to in Brownlie number 1 is Distillers and Thompson, and it's at 3871, please.
I just wonder, before we leave it, just speaking off the cuff, I wonder if you might make something of the fact that the two alternatives.
That's what I was going to do via Distillers, my lord. We do. So there's definitely two limbs here. So it's act committed or damage sustained. I'll cut to the chase. I'll get to my submission rather than stringing you out. But we say that the change is clearly made in the context of the previous rule having been too narrow and very difficult to apply. And I'll take you in a minute to a couple of authorities where there's a couple of expressions of judicial exasperation about the old rule. But the old rule in Distillers had been held to be that it is where the substance of the tort was, which is equivalent to the acts constituting the tort where they were committed. And the damage limb was added as an additional limb, additional basis on which the court might permissively hold jurisdiction. It doesn't oblige the court ever to hear a claim, but it permits it to. And we say it was clear purpose to make it wider. Now, it's possible, as some judges have said previously, that that was inspired by the facts of Bière and Mine de Potasse, where you had the environmental damage, the act occurring in country A, and all the harm, including the immediate physical harm arising in country B. It's possible that it arose on that basis. We submit that it might also have arisen in the context of some of the Commonwealth authorities that were being decided around that time. If we could quickly have a look at Distillers, and then I'll take you to a couple of the Commonwealth authorities then to make that point good, if I may, please. So Distillers is 3871. What happened in Distillers, it was a thalidomide action. The unborn child was damaged in the womb in New South Wales because her mother ingested thalidomide, which had been sold by an English company and packaged without any warning as to the risks that it posed. And the Privy Council had to answer the question whether the plaintiff could sue in New South Wales or not. And as it was a tort claim, under the old rule, it was necessary to work out what that meant, and it had obviously been causing quite a lot of difficulty. And you can see from the judgment of Lord Pearson at 3870 that there were three different possible interpretations advanced as to what the old rule might mean. The old rule said, section 184A, there is a cause of action which arose within the jurisdiction. And I just pause there to note that the old rule did refer to a cause of action and our rule doesn't. The first alternative was that the cause of action must be the whole cause of action, so that every part of it, every ingredient must have occurred within the jurisdiction. 2, that it's necessary and sufficient that the last ingredient of the cause of action, the event which completes the cause of action and brings it into being, has occurred in the jurisdiction. Or 3, that the act on the part of the defendant which gives the plaintiff his cause of complaint must have occurred within the jurisdiction. And they then go on to look at the different alternatives. And at 3871, they look at, they dismiss one quite quickly, but at 3871 at letter E, they look at the second solution, namely that the last ingredient of the cause of action, the event which completes a cause of action and brings it into being, has occurred within the jurisdiction. So in most negligence cases, that's the damage, because obviously the cause of action isn't complete without the damage. And at 3871, they say this, that the last event might happen in a particular case to be the determining factor on its own merits by reason of its inherent importance, but not because it's the last event. Then they observe that decisions under statutes of limitation are not applicable. And my submission is that that's the Privy Council saying that when you're looking at jurisdiction grounds, you're not assimilating anything to what might be considered a completed cause of action for limitation purposes, which is something to bear in mind when reading Lord Sumption's minority judgment in Brownlie number 1, where he appears to make exactly that assimilation. The question in that context being, when did the cause of action accrue so that the plaintiff became able to sue? The answer is that the cause of action accrued when it became complete, as the plaintiff cannot sue before then. But when the question is in which country's court should have jurisdiction to try the action, the approach should be different. So what they're saying here is that when you're looking at jurisdiction gateways and jurisdiction rules, it's a different approach to interpretation than what you're taking when you're looking at completion of a cause of action. The search is for the most appropriate court to try the action, and the degree of connection between the cause of action and the country concerned should be the determining factor. And then right at the bottom of the page, the sentence starts, in a negligence case, the happening of damage to the plaintiff is a necessary ingredient in the cause of action, and it's the last event completing the cause of action. But the place where it happens may be quite fortuitous and should not of itself be the sole determinant of jurisdiction. And then at letter E, they say what the right approach is. The right approach is, when the tort is complete, to look back over the series of events constituting it and ask the question, where in substance did this cause of action arise? And I submit that there's a really good steer in this judgment as to the interpretive approach to be taken to the gateways. In other words, the Privy Council is saying, look at the substance and not at the form. It's not a technical rule, and they're not designed as such. They never have been. They then go on to look at option 3, and just for completeness, so you know what actually happens in the case, that's what they go with. They do at the bottom of 3872 discuss some difficult cases about damage arising in one country and the act occurring in another, and then they simply brush it off by saying the problem is a difficult one and there's no need to express any opinion on it on the present case, which is right, because they then went on to find that the misrepresentation had been made to the plaintiff's mother in New South Wales, not misrepresentation, apologies, the omission to provide a warning had been made in New South Wales because the packaging had been received there and didn't have the leaflet in it, or the leaflet didn't say anything about the dangers. And so the act and the damage were actually in the same country. Now, the effect of that decision, I'll come to you if I may. The effect of that decision was to limit effectively tort case jurisdiction to the act which was the substance of the tort and not to the damage. And that was what was being overruled effectively when the rules were changed in 1983. I do apologise, my Lord Legate.
No, shouldn't apologise. I was just noticing Lord Pearson's observation that it's not manifestly just or reasonable that the defendant should have to answer for his wrongdoing in any country in the world to which the plaintiff or the plaintiff's mother may have happened to go before the damage occurred. That's 468D. Might you not say the same about where the plaintiff or the plaintiff's relative happened to go after the damage occurred?
Well, my Lord, the example that he posits, in my submission, two things. One is a relatively unusual one because he interposes travel of the plaintiff's mother, I think, to South Africa on his example and back again. But as we'll come on to see, in my submission, what's happened in the Commonwealth authorities is that that hasn't been seen to be of significant concern. And in practice, I would additionally submit that that would be the classic case for forum non-conveniens to take a step in to say, well, what issues actually are being tried here, and what is the appropriate place for this case? And one could see that a defendant might have quite substantial grounds to say that England wasn't the natural and proper place for the forum if there'd been that kind of moving about. But I would, if I may, please like to go to the Weil and Von Vent decision, which is a Canadian case, which and the reference is 5193. So we can see at 5190, first of all, sorry, that the facts are quite straightforward. There was a road accident in Quebec. Sorry, well, it was kind of a road accident. It was unloading of a concrete statue from a truck. The plaintiff was taken to hospital in Ontario, and then the action was brought against 6 defendants, 4 of whom were served in Ontario. The question is, I think the statue was a statue of a horse or something. I seem to remember from reading it before. But the at 5193, towards the bottom, the court concludes, we are of the opinion that the defendant Von Vent could properly be served pursuant to the rules of 251H, which reads as follows: in respect of damage sustained in Ontario arising from a tort or breach of contract committed elsewhere. So this case was decided in 1979, so 2 or 3 years after the Bière case, but 2 or 3 years before the English rules were changed. We're all of the view that the plaintiff sustained damage in Ontario, which arose from a tort committed elsewhere, that is in Quebec. Although the accident and injury to Weil took place in Quebec and he sustained some damage there, the bulk of the damage that flowed from the injury was sustained in Ontario. The word damage is usually used to refer to a particular head of loss for which compensation is awarded. The word damage is generally used to identify the amount of money which is paid by the tortfeasor for inflicting the various items of damage. Damage caused by tortious conduct may consist of several different items, all of which may be consented by money damages. And then they set out what the damages are. And then halfway down the page, we are of the opinion it was the intention of the legislature in amending the rule to enable people of Ontario to use their own courts more easily to sue tortfeasors for damage sustained in Ontario as a result of torts that were committed elsewhere. Earlier decisions based on the old rules had required Ontario residents to pursue foreign tortfeasors, such as negligent manufacturers abroad, often causing considerable financial hardship to victims. The legislature decided to rectify this situation. And then over the page at 5195, having discussed the case of Marr and Block, with respect, we disagree with the conclusion. We feel the learned trial judge confused the word damage with injury. Damage certainly includes injury, but it also includes more than that. It includes all the different heads of damage and various expenses that may be suffered as a result of tortious conduct. And I pause momentarily to observe that the words in this field are used interchangeably. Harm and damage and injury and even damages can be used by different people in different contexts in different ways. And then it goes on to say, if the legislature wished to allow plaintiffs to serve foreign defendants only in situations where an injury occurred in Ontario, it could have worded the rule in that way. Rather, the rule employs the word damage, which in our view is a much broader concept than the word injury. Now, in my submission, there's no reason to suppose that the Rules Committee in 1983 were not aware of that decision. In fact, if they were kind of looking about them for ways to do this, and they had a choice between following the European scheme, which uses the word harmful event, or the Commonwealth Authority scheme, which uses the word damage, we would submit that there's nothing to suggest that there's particular impetus for the European law one way or the other. In fact, if anything, the choice of the rules suggests rather that they had cases like this in mind, rather than the narrower rule. We can see how the issue was dealt with in Australia about the same time in the case of...
Just before we leave that, it may be the next paragraph may have a bearing on the fatal accident claim.
Oh, I'm sorry.
Well, it gives the example of the plaintiff having been, hypothesis that the plaintiff had been killed in the accident, and they asked, would his family have been forced to pursue the tortfeasor in Quebec on the ground that the damage to them occurred there? We think not, although the fatal injury would have occurred in Quebec, his family, if living in Ontario, would have suffered their damage in Ontario.
Well, exactly. I mean, it depends on what heads of loss are claimed, of course. I mean, in a wrongful death claim, and as we've seen from the Egyptian law evidence, one can claim expenses, one can claim a kind of moral damages, but one can also claim a dependency. And so it would very much depend on particular facts of a particular case as to what losses had in fact arisen on the particular facts as to whether any significant damage had occurred in a particular place or not. So I wouldn't want my comments to be seen as a kind of general wider application, but certainly on the facts of this case, given Lady Brownlie's domicile in England, insofar as, and Sirian's domicile in England as well, it seems natural to suppose that her financial dependency upon him did arise in England, but I'm not sure that this court necessarily needs to determine that point. But these are, in our submission, the kind of factual questions which first instance judges are well capable and used to deciding. It doesn't create any particular. There's no need to create a particular rule on that, but. Well, we wouldn't necessarily disagree with that observation, but we wouldn't necessarily say that it's part of this court's task to endorse it one way or the other. But yes, thank you for drawing that to my attention, because I hadn't seen that. Can we have a look at Challoner, please, which is at 4752. Can you give me the tab? Thank you. Now, this case was decided in October 1983, which was just shortly after the statutory instrument was made that we looked at with the rules in. But we can see at 4750 that Weil and von Wendt was cited to this court. And you can see the arguments about we can see the rule is at 4751, where the proceedings are founded on or for the recovery of damage suffered wholly or partly in the state caused by a tortious act or omission wherever occurring. And at the top of 4752, the defendant's argument is set out, the familiar one. There is a distinction to be drawn between damage and the consequences of damage. Here, the plaintiff suffered his damage in Queensland, a broken calcaneum and shock. The damage had other consequences, but they were consequences of damage, not damage itself. And then it talks about earnings capacity and interference with profitability of his engineering business, said to be merely a consequence or effect. And then reference is obviously made to distillers, and then some fairly disparaging comments about English judges, which I won't read out loud. And then at letter E, in the present case, this court is not concerned, at least not directly, with where the plaintiff's present cause of action arose, but with whether, despite the fact that the cause of action arose in Queensland, part of the damage caused to the plaintiff, by the defendant's act or omission was suffered in this state. By argument, counsel for the defendant seeks to develop from the speeches of distillers that the cause of action was completed in Queensland, and the damage was a necessary ingredient to complete the cause of action. The damage suffered must have been wholly in Queensland, etc., etc. And then the judge picks up his pen with a flourish. To me, that argument is like the lagoon at Venice, bright, colourful, and at times even dazzling, wide to the horizons in its breadth, but a few feet deep. While the fundamental principle lies full 5 fathom 5, damage is damage. I'm tempted at that point to observe that after reading many, many cases on this question, in the end, damage is damage. It may be at least in part bodily injury, e.g. a motor vehicle industrial accident case. It may be financial loss, as in breach of contract. It may be for outraged feelings or diminished reputation, false imprisonment or defamation. It may be direct. It may be indirect. It may be consequential. It is still all damage. For the defendant's submissions to be successful, this court would need only to hold that the initial bodily injury in such pain had in Queensland is damage and all else is not. I do not accept this. At letter B, it includes injury and loss, it includes consequential damage. And then at letter D, he goes on to give an example of how the narrow rule can cause obvious injustice. So he says, if you had a star New South Wales rugby league player knocked down by a negligently driven car at Coolangatta in Queensland, who suffers immediate pain, is taken to Tweed Heads Hospital on New South Wales side of the border, where surgeons are forced to amputate his leg. After several weeks in hospital, he's returned to his home at Randwick in Sydney to convalesce. Almost all of his pain and suffering is in New South Wales. Every one of these matters is clearly damage, which even if it stood alone would be damage sufficient to sustain an action based on the defendant's negligence. So my submission is that the direction of travel of the Commonwealth cases was, first of all, to have a broad and general rule about damage as a potential connecting factor in tort cases for jurisdiction. But secondly, that to reject any technical divisions of the meaning of damage. And my submission is that the draftsman can be taken to have had those cases just as much in mind as the case of Bier. It is true to say that in many of the subsequent English cases, it has been recited that the purpose of the 1983 rule was to was inspired by the European law. Nobody really is in a position to explain that. There aren't any explanatory notes, there aren't any travaux, there's no working group paper or report. Well, certainly not one that anybody's managed to turn up in the many, many occasions, particularly in this case, that this issue has been before the court. And in my submission, that it may just have been an assumption made on the basis that it's in the same statutory instrument as the other provisions that clearly do implement the European law, but not this one. So in our submission, we say that the Commonwealth Authority and the background of the common law supports our approach not only to what the natural and ordinary meaning of the word is, but also how to look at the purpose of the gateway, and that notions of cause of action and those technical concepts are to be put to one side. And Professor Briggs also endorses that approach. I won't take you to him, but it's at 3356 in the bundle, where Professor Briggs also says that the change is to move away from looking at cause of action or form and to go to a more substantive approach. For those reasons, we submit that the majority in Brownlie number 1 on the previous occasion that this very issue in this case was before the Supreme Court was quite right to take the approach that it did. And we do submit that Lord Sumption was wrong in his approach, because and maybe it's worth having, I know we looked at it yesterday, but maybe it's worth going back and having a little look at how Lord Sumption deals with it. I think it's at tab 10, isn't it? Ooh. Tab 9. 1782. He picks up the topic of the ground, and he does refer to the Commonwealth cases at paragraph 21. But then he at paragraph 23 says there's a more fundamental reason that damage means direct damage. It contains the nature of the duty broken in a personal injury action. So he's coming at it from a completely different perspective to the older authorities as to how the tort ground should be interpreted, and in my submission, an erroneous one in light of those authorities. He does then curiously say at the bottom of that paragraph 23, I would readily accept that damage, as that word is used in the rule, is not necessarily limited to damage which serves to complete the cause of action in tort, but the two concepts are clearly related, even if they are not coterminous. We've struggled to really parse that in any sensible fashion. I perhaps pass that ball over to your lordships, but we think that the essence of Lord Sumption's reasoning is indeed to say that it's damage which completes the cause of action for the purpose of the gateway, and we struggle to see how he maintains that reservation. And just immediately above that sentence, he does talk about damage being an essential element of cause of action in tort, and the limitation period in respect of damage thrown to a breach run from that time, which again was expressly disavowed in Distillers by the Privy Council as being a relevant notion for the purpose of interpretation of the gateways. Now, I would quite like to have a look, if we may, at the Australian case of Flaherty and Geargis, because we say that that also provides useful guidance for this court in the personal injury context as to how the concept of damage for jurisdictional gateways ought to be viewed. It's at 1795. Oh, sorry, hang on, no, 4786, that's where it comes up in Brownlie, sorry.
Ms. Crowther?
Yes. Oh, I'm sorry.
Sorry, just before you leave Lord Sumption, I mean, isn't it difficulty with the approach that would say it's damage necessary to constitute the cause of action, that one will have to have a different approach to torts that are actionable per se, which I think is a point that Lady Hale meant, and might that not be why Lord Sumption couldn't ultimately tie the damage that constitutes the cause of action, couldn't tie it up finally as if they were coterminous because of torts actionable per se?
That may be right, my lord, and that hadn't been something I thought of. Thank you very much. But I mean, one thing that I might observe that flows from that is that Lady Hale was surely right then, that in those cases there's an anomaly, isn't there? Because what purpose does the damaged limb of the gateway serve? So if it's not completion of a cause of action, which is the touchstone, what is it? Because one of the issues in this case is that the defendant kind of posits for a narrower construction of the rule, but does so in slightly different ways. We submit that those different ways are not consistent with each other, and you can't have it all. I mean, I'm straying slightly off point, but we do say that you can't run the kind of European law interpretation and run the domestic common law cause of action point at the same time, because as we'll come on to see, questions of what constitutes the tort as a matter of national law are in European law completely irrelevant. It's all autonomous. So we say that another problem in Lord Sumption's judgment is that he's riding two horses here, which aren't necessarily, you can't do. But certainly in respect of this question of if it's going to be completion of the cause of action, then if your lordships were tempted to go down that road, then one of the issues that one would have to grapple with in our respectful submission is where that leaves torts that don't have damage as completion of the cause of action, because either they're in or they're not. Either the damage limit means something in those cases or it doesn't. On our approach, we submit that you simply don't need to get into that. This is simply a question of, in personal injury cases, what does damage for jurisdictional purposes mean? And we say that, and we'll come to look at Matal in due course. If one looks at Matal and the cases I've already taken you to, any sufficient damage in the jurisdiction is sufficient. And then in the context of personal injury, there have been a whole string of first instance, fully reasoned decisions where it has been, where the Matal principle has been applied. And you can see that that's been applied to say that any significant damage in a personal injury case means any significant damage, no more and no less. So we say that to decide it our way, you don't need to really get into all of those questions. But there are difficulties we submit conceptually with the cause of action approach, partly because it was rejected in distillers, partly because it's inconsistent with European law, partly because it's anomalous for torts that don't have loss as an essential part of the cause of action. But without being kind of horrible, I guess those are questions not for me because they're not part of my case, but there are issues that then do arise. I hope I answered the question in what then turned into a mini speech. Would it be possible for us to look at Flaherty and Geergis? It's 4786. This is the next in the chronology. It's December 1985. And it's the Supreme Court of New South Wales. And in what is now becoming a reasonably familiar fact pattern, there's a road accident in one place and to a resident who lives somewhere else. You can see that Challoner and Douglas was cited to the court, and it's the judgment of President Kirby, and it starts at 4788, and he says towards the top of that page, a claim is expressed, the claimant's claim is expressed, includes a claim for the injuries and losses suffered in Queensland as well as those suffered in this state. She seeks to bring her proceedings against the appellant in the Supreme Court of this state rather than in Queensland where the tort was committed. In some cases of this kind, nothing more may be involved in such an election of jurisdiction than the convenience of the claimant and most of her witnesses. Other considerations may sometimes intrude, including different court practices, facilities, differing delays in the hearing of cases, levels and quantification of damage, limitation periods, and so on. These
I'm sorry to interrupt you. We've lost a video link from Mr. Palmer. Can I just check that he is still able to follow the proceeding?
Oh, I hadn't noticed. I'm sorry.
I'm so sorry, my lord. I touched my screen with my hand by mistake. I didn't realise I'd turned my video off.
That's fine.
I will now mute myself.
That's fine. Thank you. Carry on, Ms. Crowther.
Good. Does that mean that I don't need to repeat anything? We've got everything.
We've got everything.
Okay.
I had everything.
Okay, good. So the rule is at the bottom of 4788. And it says where the proceedings are founded on or for the recovery of damage suffered wholly or partly in the state, caused by a tortious act or omission wherever occurring. And then the issue is right at the bottom of that page, little I, whether damage referred to in the rule means only the immediate consequences of the proposed defendant's tort, i.e. in the present case, immediate physical injuries and losses, as distinct from the longer term physical losses, and whether damage means only that damage which constitutes the necessary element of the cause of action, and also whether damage within the rule, that is little 3, includes consequential loss, and therefore is only in relation to New South Wales, a kind of backup limiting argument. In other words, to say you can only sue for the loss that was actually here. And then in the judgment of McHugh, JA at 4802, there's a heading construction of part 10 of Rule 11E. And he refers there to the Challoner and Douglas decision, and also says that Mr. Justice Hunt followed it in the present case. The defendant's submission must be rejected. In Crofter, Handwoven, Harris, Tweed and Vetch, Viscount Simon pointed out that injury is limited to actionable wrong, while damage in contrast with injury means loss or harm occurring in fact, whether actionable as an injury or not. Damage, therefore, is to be contrasted with the element necessary to complete a cause of action. It includes all the detriment, physical, financial and social, which the plaintiff suffers as a result of the tortious conduct of the defendant. Then the defendant tried to run the distiller's point that it's all about completion of a cause of action. That was rejected. I cannot see how it follows that the word damage is necessarily confined to the immediate consequences of the tortious act or omission of the defendant. The rule overcomes the reasoning in Thompson, where the damage is given the narrow meaning for which Mr. Handy contends, or the wider meaning to which Viscount Simon refers in Vetch's case. And then the final argument that it includes, damage includes consequential loss, but only that consequential loss which arises in the jurisdiction is dealt with over the page. So we rely on that as the approach which we would commend this court to take. It's the approach which the majority in this case, last time this issue was before it, took. And we would submit that there is no good reason to depart from that approach. I may make a couple of further points about Lord Sumption's reasoning, if I may. He departs from property damage and refers to the case of Dimmond and Lavelle, which is a well-known discussion about impecuniosity of claimants in the context of replacement car hire following vehicle accidents. And he reasons out from that in saying that the damage, if I crash my car in terms of bent bumper and damaged paintwork, is essentially an economic one, because I had a car before the crash which was worth X, and after the crash I've got a car which is worth slightly less than X because of the damage that's been done to it. And so the heads of loss which arise almost presumptively are the cost of repair of that damage, the diminution in value, I suppose, is one way of looking at it, and also the loss of use of the vehicle for the period whilst it's being repaired. He then reasons across from that into saying that personal injury is no different. We fundamentally, with respect, disagree with that characterization. That is not a logical step, and we submit that there is no authority for the proposition that in the context of jurisdiction, personal injury should be seen the same as property damage. In fact, for all the reasons that I've taken your lordships to about the nature of personal injury damage, there are very good reasons why it should not be seen in that fashion. And so for those reasons, we submit that with a strange starting point and what we would respectfully say is a bit of a logical misstep, Lord Sumption then introduces the cause of action cases, which we can see from Distillers and the other cases are respectfully not the correct approach. Can I please then turn to the Mattal decision, which my learned friend took you to at some length yesterday. We do deal with Mattal in our written case in some detail at paragraphs 20 to 23, which is at electronic 117 to 118. I'm grateful to my learned friend for taking the court through the facts of that case. But the essential point that we submit needs to be taken from Mattal is that the damage occurred both in Belgium and in London, because the damage that was material was the failure to deliver the warrants. And Therefore, the decision was that it was sufficient that some damage had occurred in London. And I know you were taken to the passage which refers to the loss being in London, etc., etc. And my submission is that that passage needs to be seen in the context that there was a finding that there was also loss of the same nature in Belgium. And the question before the court was whether all of the damage needed to have been in London or not, or whether just part of it. And the conclusion was that there was sufficient damage in London for the gateway to be met. And we say that the proposition of law that comes out of Metal is that any significant damage sustained in the jurisdiction is sufficient to found or to pass through the gateway to cross the threshold. Yes, my Lord Legate.
However, damage was not sustained in Switzerland, was it, where the company was based and felt the loss?
That's right. And
it was sustained where the injury occurred.
And I don't shy away from the fact that in the economic tort cases, the courts have had to grapple a great deal with the taxonomy of what really damage is in the context of economic torts, because one can look at damage at various levels of generality. One can take a very high level view, or one can move down the chain into heads of loss or financials. And understandably, we submit that in the economic tort cases, there is a reluctance to found jurisdiction on what might be seen as pure monetary loss or bank account losses. So it's not generally in the economic tort cases sufficient to say, well, my situs is Switzerland and that's where my bank account is, and therefore I've sustained damage there. But we
are you drawing a distinction between financial loss and pain, but for your purposes? I mean, or are you saying that it's enough that financial consequences of an accident are suffered in this country? For example, if somebody is unable to earn money in England.
I submit it is enough if financial consequences and money arising from personal injury are, because if one thinks about it in practice, the reason that you are unable to earn losses over a sustained period of time is because you are sufficiently injured still and suffering the consequences of it that you're prohibited from doing the work which you would otherwise have done. It's not the case that you have a single incident and then that triggers an ongoing loss. What a lot of the cases have in practice had to focus on is not so much the question of what is damage, but as where is the relevant damage sustained. And it is difficult sometimes when reading the cases to be completely clear what side of the line different decisions are falling, what particular issue is especially in mind. But we say on a proper reading of Metal, in circumstances where there was a finding of loss in Belgium and loss in London, what it found was that if there was significant damage in London, then that was enough to pass the gateway test or to cross the threshold. And that was
what I don't see at the moment, sorry, one more question, is what the distinction, why there should be a distinction drawn between the injury and its consequences in these economic cases, but not in the personal injury cases.
Because in my submission, generally in the economic cases, what you're talking about is a single instance of loss, a little bit like the damage to the bumper of the vehicle, that once it's done, it's done. There are some economic tort cases where it's different, and we can look at conductive inkjet, if you like, where there was a claim about damage to the ongoing commercial activities of the claimant within the market because of breaches of intellectual property and other rights. And that was also held to be significant enough damage to meet the threshold test. So it's very fact sensitive, and I hope I'm not dodging the question to say that it's not very easy for this court to draw firm distinctions, which really brings me back to where I started, which my primary submission really is that damage is a general rule and it's a flexible application, and it's deliberately designed in that fashion, and it's intended to focus on the substance and not the form. And it works well, and it has worked well on the basis of what the Court of Appeals said in Mittal, which is that the court has to be satisfied that there's damage that is significant in all the circumstances. But once that is satisfied, then there is permission for the court to consider jurisdiction. Not that it has to order jurisdiction, and we may need to look at forum non-convenience this afternoon now, but it's certainly enough to get through the permissive stage of this two-stage process. And the difficulty with trying to have high-level or technical distinctions or narrowing on it is that because of the very wide range of circumstances that this tort rule has to cater for, you just inevitably get into difficulties. We also say that there's no difficulty with having this rule. I know there was discussion yesterday about the question of whether it would be somehow a floodgate or opening it up so wide as to introduce forum shopping. But in our submission, that's not a realistic way of looking at what happens in personal injury cases. It's a very rare individual who genuinely hops around the globe, particularly when they're badly injured. The overwhelming pattern is that people have either been abroad for a holiday or a short period of work, and they sustain a very bad injury, and they effectively come home because that's where they need their life to be. It's where their family generally is. It's where they can get care. It's where people speak their language. I think somebody said yesterday, the sky hasn't fallen in, and I would respectfully agree. And I said the reason for that is that the idea that people are coming to England solely for the purpose of being able to establish jurisdiction for a claim is for the birds. That's not what happens in these cases where people are very badly injured. And we do say that if the rule is narrowly construed, then there is a very grave risk of injustice, because then you will have cases such as Pike, which Lord Wilson refers to in his judgment, where England is the only possible forum. And if the gateway isn't wide enough to cater for that, then those very badly injured, I mean, Mr. Pike had he was 30 years old with a spinal cord injury. Those very badly injured people have no claim at all. They've got no practical access to justice. Yes, my lord.
But is it our job as the courts here to make up for the deficiency of other legal systems? I mean, if there's no proper connection with England, that isn't good enough, is it, to say, well, you've suffered an injustice and we'll provide you with a remedy, because the other place wouldn't?
Well, I don't want to get into political or philosophical questions, but in the context of whether to take a wide definition of the gateway or a narrow definition of the gateway, what we say is that there is no risk of injustice on our interpretation of the gateway, partly because of the forum non-convenience discretion, which I will have to address this afternoon, but partly because it can be seen that in practice it's not been a problem. On the other hand, if one takes a narrow construction, then one has to embrace the fact that one is creating situations where England would be the appropriate forum, in fact, possibly the only appropriate forum on the Spiliada test, and yet it would not be possible for that claimant to bring his claim here because the word damage in the gateway has been construed narrowly. That's we say, something that this court should be slow to countenance, and there's no obvious reason for it to do so. Now, my lords, I was, unless there are further questions, I was about to move on to another topic. I've got one eye on the clock. I don't know if this is a convenient moment or you would like me to I think we're doing. I think we're doing fine for time, if I may make that observation. So. Oh, it's hang on. I'm very sorry, my lord. I'm afraid I can't hear on the connection.
Can you hear me now? I'm sorry, I just needed to get a bit closer to the microphone. Well, thank you very much, Ms. Crowther. We'll adjourn just now in that case and resume at 2 o'clock.